of the existing justice delivery system. Defects of the existing justice delivery system. The justice delivery system, despite its importance, faces several challenges. Here are some of the primary defects. Delays and pendency. Excessive caseload. Courts are overburdened with cases, leading to inordinate delays. Complex procedures. Lengthy and complex legal procedures contribute to the delay. Lack of infrastructure. Insufficient courtrooms, staff, and technology hinder efficiency. Lack of access to justice. Financial barriers. Legal services are often expensive, limiting access for the poor. Geographical barriers. Lack of adequate legal infrastructure in rural areas. Lack of legal awareness. Many people are unaware of their legal rights and remedies. Corruption. Bribery and favoritism. Corruption undermines the integrity of the justice system. Delay in justice. Corruption often leads to delays in case disposal. Lack of transparency and accountability. Opaque processes. Lack of transparency in judicial appointments and decision-making. Limited accountability. Judges are often shielded from scrutiny. Inadequate infrastructure. Shortage of judges and support staff. Lack of sufficient personnel to handle the caseload. Outdated technology. Reliance on manual processes and lack of modern technology. Low public confidence. Delay in justice. Public perception of the judiciary as inefficient. Corruption. Cases of corruption erode public trust. Complex procedures. Difficulty in understanding legal processes. These are some of the major challenges faced by the justice delivery system. Addressing these issues is crucial for ensuring access to justice for all. Question 31. International Commercial Arbitration. International Commercial Arbitration. International commercial arbitration is a dispute resolution mechanism where parties from different countries agree to submit their commercial disputes to one or more arbitrators for a final and binding decision, rather than litigating in the courts of either country. Key characteristics. Cross-border disputes involves parties from different countries. Party autonomy. Parties have significant control over the process, including the choice of arbitrators, the procedural rules, and the place of arbitration. Neutrality. Arbitrators are typically chosen for their neutrality and expertise in the relevant field. Confidentiality. Proceedings are generally confidential. Enforceability. Awards are typically enforceable in multiple jurisdictions due to the New York Convention. Advantages of international commercial arbitration. Efficiency. Often quicker and less complex than litigation. Expertise. Arbitrators are usually experts in the relevant field. Neutrality removes home court advantage. Confidentiality protects sensitive business information. Enforceability. Awards are generally enforceable worldwide. Challenges of international commercial arbitration. Complexity. Dealing with different legal systems and cultures can be complex. Cost can be expensive, especially for complex disputes. Enforcement. While the New York Convention facilitates enforcement, there can still be challenges in certain jurisdictions. Key international instruments. New York Convention, the most important treaty governing the recognition and enforcement of foreign arbitral awards. UNCITRAL Model Law provides a framework for national arbitration laws. International commercial arbitration has become a preferred method of dispute resolution for businesses engaged in cross-border transactions due to its efficiency, flexibility, and enforceability. Question 32. Effect of insolvency of party. Effect of insolvency of a party on arbitration. The insolvency of a party significantly impacts an ongoing arbitration proceeding. The exact consequences depend on the stage of the insolvency process and the applicable insolvency law. Key considerations. Stay of arbitration. Upon the commencement of insolvency proceedings, there might be a stay of arbitration proceedings. This is to protect the rights of all creditors and ensure equitable distribution of assets. Role of insolvency practitioner. The insolvency practitioner, IP, or receiver appointed in the insolvency proceedings assumes control over the insolvent party's assets and liabilities. They have the discretion to decide whether to continue the arbitration or not. Adoption or rejection of contract. The IP can choose to adopt the contract containing the arbitration clause, in which case the arbitration can proceed with the IP representing the insolvent party. Alternatively, the IP can reject the contract, terminating the arbitration. Impact on arbitration agreement. If the arbitration agreement was entered into after the commencement of insolvency proceedings, its validity might be challenged. Claim as a creditor. The claim arising from the arbitration becomes a part of the insolvency proceedings and is treated as a debt of the insolvent party. Distribution of proceeds. Any award obtained in the arbitration would be treated as an asset of the insolvent estate and distributed among the creditors as per the insolvency resolution process. Important considerations. The specific provisions of the applicable insolvency law govern the impact of insolvency on arbitration. The stage of the insolvency proceedings, pre-insolvency, moratorium, liquidation, affects the available options. The terms of the arbitration agreement and the nature of the dispute are crucial factors. It is essential to consult with legal counsel to understand the specific implications of insolvency on an arbitration in a given jurisdiction. Question 33. Appeal against the order of Arbitral Tribunal. Appeal against the order of an Arbitral Tribunal. Generally, there is a limited scope for appeal against the orders of an arbitral tribunal. The principle underlying arbitration is party autonomy and finality of the award. However, there are specific exceptions provided under the Arbitration and Conciliation Act, 1996. Section 37 of the Arbitration and Conciliation Act, 1996. This section outlines the appealable orders. Appeal against orders refusing to refer the parties to arbitration. If a court refuses to refer a dispute to arbitration when it should have, an appeal can be filed. Appeal against interim measures. An appeal can be filed against an order granting or refusing interim measures under Section 17 of the Act. Appeal against setting aside or refusing to set aside an arbitral award. An appeal can be filed against a court's decision to set aside or refuse to set aside an arbitral award under Section 34. Important points to remember. The scope of appeal is limited to the specific orders mentioned in Section 37. The appeal lies to the court authorized to hear appeals from original decrees of the court passing the order. There is no second appeal from an order passed in appeal under Section 37. It is crucial to note that the general trend is to limit judicial intervention in arbitration proceedings. The emphasis is on finality of the arbitral award. Would you like to know more about the grounds for setting aside an award or the procedure for challenging an award? Question 34. Under what circumstances judicial interference is required under arbitration proceeding? Judicial interference in arbitration proceedings. The principle of minimal judicial intervention is a cornerstone of arbitration. However, there are specific circumstances where court intervention is warranted. Circumstances requiring judicial interference. Appointment of arbitrators. When parties fail to agree on the appointment of an arbitrator. When a vacancy arises in the arbitral tribunal. Interim measures. In exceptional circumstances, when the arbitral tribunal cannot provide adequate interim relief, the court may intervene under Section 17 of the Arbitration and Conciliation Act, 1996. Challenge to arbitral award. When a party believes the award is contrary to public policy, or suffers from procedural impropriety, or is beyond the scope of the arbitration agreement, the court may intervene under Section 34 of the Act. Enforcement of arbitral award. The court's role is crucial in enforcing the arbitral award, treating it as a decree of the court. Supervisory jurisdiction. In limited cases, the court may exercise supervisory jurisdiction to ensure the arbitral process is conducted fairly. Key points. The court's role is primarily supervisory and intervenes only in exceptional circumstances. The principle of party autonomy is paramount, and the court's intervention is limited. The grounds for judicial intervention are strictly defined under the Arbitration and Conciliation Act, 1996. In essence, judicial interference is the exception rather than the rule in arbitration. The goal is to maintain the efficiency and autonomy of the arbitral process while ensuring fairness and justice. Question 35. Grounds for termination of arbitration proceeding. Grounds for termination of arbitration proceedings. The Arbitration and Conciliation Act, 1996, provides for several grounds on which an arbitration proceeding can be terminated. Termination by award. Final award. The most common way to terminate arbitration proceedings is through the issuance of a final award by the Arbitral Tribunal. This concludes the dispute and brings the proceedings to a close. Termination by order of the Arbitral Tribunal. Withdrawal of claim. If the claimant withdraws their claim, the tribunal can terminate the proceedings unless the respondent objects. Agreement of parties. If the parties mutually agree to terminate the proceedings, the tribunal can issue an order accordingly. Impossibility or unnecessary continuation. In exceptional circumstances, if the tribunal finds that continuing the proceedings is impossible or unnecessary, it can order termination. Other grounds. Death of a party. While the arbitration agreement survives the death of a party, in certain circumstances, the proceedings might be terminated or suspended. Insolvency of a party. The insolvency of a party can impact the arbitration proceedings and may lead to termination under certain conditions. It's important to note that the power to terminate arbitration proceedings primarily rests with the Arbitral Tribunal. However, the parties also have a role to play in deciding the fate of the proceedings. Question 36. Grounds for setting aside of arbitration award. Grounds for setting aside an arbitration award. Section 34 of the Arbitration and Conciliation Act, 1996, outlines the grounds on which an arbitral award can be set aside. These include 1. Incapacity or misrepresentation. A party was under incapacity at the time of the arbitration agreement. The arbitration agreement was induced by fraud or corruption. 2. Lack of proper notice. A party was not given proper notice of the appointment of the arbitrator or of the arbitration proceedings. 3. Composition of arbitral tribunal or arbitral procedure. The composition of the arbitral tribunal or the arbitral procedure did not comply with the agreement of the parties or, failing such agreement, was not in accordance with the law. 4. Beyond the scope of submission. The award deals with a dispute not contemplated by or not falling within the terms of the submission to arbitration. 5. Corruption or undue influence. The award has been procured by fraud or corruption, or the arbitrator has been guilty of misconduct. 6. Public policy. The award is in conflict with the public policy of India. 7. Lack of reasons. The award contains no reasons or insufficient reasons to enable the court to determine the question of law or fact. It's important to note that the burden of proof to establish any of these grounds lies with the party seeking to set aside the award. Additionally, the scope for setting aside an award is limited. Courts generally adopt a cautious approach to interfering with arbitral awards. Question 37. State the difference between arbitrator and referee. Arbitrator versus referee. While both arbitrators and referees are third-party neutral individuals involved in dispute resolution, there are distinct differences between the two roles. Arbitrator. Decision-making authority. An arbitrator has the power to make a final and binding decision on a dispute. Their decision is equivalent to a court judgment. Formal process. Arbitration typically follows a formal process, including hearings, evidence presentation, and written awards. Contractual basis. Arbitration usually arises from an arbitration agreement between the parties. Referee. Fact-finding role. A referee is often tasked with determining facts or issues in a dispute, but does not typically have the authority to make a final binding decision. Limited scope. The referee's role is usually more limited than an arbitrator's, focusing on specific questions or issues. Court-appointed. Referees are often appointed by courts to assist in complex cases or to resolve specific disputes. In essence, an arbitrator is a private judge with the power to make a final decision, while a referee is more of a fact-finder or expert appointed to assist the court or parties in resolving a dispute. Question 38. Explain the power of court to issue order for appearance before arbitral tribunal. Power of court to issue order for appearance before arbitral tribunal. The Arbitration and Conciliation Act, 1996, does not explicitly confer power on the court to issue an order for appearance before an arbitral tribunal. The underlying principle of arbitration is party autonomy, which implies that parties are free to determine the conduct of the proceedings. However, the court's role in arbitration is not entirely absent. In certain exceptional circumstances, the court may indirectly influence the appearance of a party before the arbitral tribunal. Indirect influence. Enforcement of interim measures. The court can enforce interim measures granted by the arbitral tribunal. This can indirectly compel a party to appear before the tribunal to comply with the order. Setting aside an award. if a party fails to appear before the arbitral tribunal without sufficient cause and an ex parte award is passed, the court may set aside the award if the aggrieved party can establish that they were prevented from presenting their case. Contempt proceedings. In rare cases, if a party willfully disobeys a court order related to arbitration, contempt proceedings might be initiated. This could indirectly compel the party's appearance. It's crucial to note that the court's role is limited, and the primary responsibility for ensuring the appearance of parties lies with the arbitral tribunal itself. The tribunal has the power to conduct the proceedings in accordance with the agreed-upon procedure, including issuing summons or notices to parties. In conclusion, while the court does not have direct power to compel appearance before an arbitral tribunal, it can indirectly influence the process through its powers to enforce interim measures, set aside awards, and initiate contempt proceedings. Question 39. When the arbitral tribunal can take the assistance of court in taking evidence? When arbitral tribunal can seek court assistance in taking evidence. Section 27 of the Arbitration and Conciliation Act, 1996 provides for the circumstances under which an arbitral tribunal can seek the assistance of the court in taking evidence. Circumstances for court assistance. Difficulty in compelling attendance. When the tribunal finds it difficult to compel the attendance of a witness or the production of documents, it can seek court assistance. Expert witnesses. If the tribunal requires the testimony of an expert witness who is reluctant to appear, it can request the court's help. Inspection of property. For inspecting property or evidence that is outside the tribunal's direct control, court assistance might be necessary. Procedure. Application. Either the tribunal itself or a party with the tribunal's approval can apply to the court for assistance. Details. The application should specify the details of the evidence required, including the name and address of the witness, the description of the document, or the property to be inspected. Court's power. The court has the discretion to execute the request by directly taking the evidence, authorizing a neutral administrator to take the evidence, ordering the evidence to be provided directly to the tribunal. Important points. The court's assistance is discretionary and not mandatory. The tribunal retains the primary responsibility for conducting the proceedings. The court's involvement is limited to aiding the tribunal in gathering evidence. In essence, the provision for court assistance is a safety net for the arbitral tribunal to ensure that it can effectively gather evidence necessary for reaching a just decision. Question 40. Can the dispute be settled amicably? Can a dispute be settled amicably? Yes, most disputes can be settled amicably. Amicable settlement involves parties reaching a mutually agreeable solution without resorting to formal legal proceedings like litigation or arbitration. It's a collaborative process that prioritizes finding common ground and preserving relationships. Methods of amicable settlement. There are several methods to achieve an amicable settlement. Negotiation, direct communication between the parties to reach a compromise. Mediation, a neutral third party, mediator, facilitates communication and helps parties find a solution. Conciliation, similar to mediation, but the conciliator may suggest potential solutions. Benefits of amicable settlement. Cost-effective, often less expensive than litigation or arbitration. Time-efficient, can resolve disputes quickly. Preserves relationships, maintains or improves relationships between parties. Flexibility, allows for creative solutions tailored to the specific needs of the parties. While not all disputes can be settled amicably, it is always worth exploring this option before resorting to formal legal proceedings. Question 41. Explain the kinds of an arbitration agreement. Kinds of arbitration agreements. There are primarily two types of arbitration agreements. 1. Arbitration clause. Part of a larger contract, this is the most common form of arbitration agreement. Embedded within a contract, the arbitration clause is included as a provision within another contract, such as a sales contract, employment contract, or construction contract. Example, a clause in a rental agreement stating that any disputes between the landlord and tenant will be resolved through arbitration. 2. Separate arbitration agreement. Standalone document, this is a separate agreement entered into solely for the purpose of resolving potential disputes. Independent of other contracts, it exists independently of any other contractual relationship between the parties. Example, a contract between two businesses specifically outlining the terms for arbitration in case of future disputes. Both types of arbitration agreements serve the same purpose of committing parties to resolve disputes through arbitration rather than litigation. The choice between the two often depends on the nature of the relationship between the parties and the specific circumstances of the dispute. Question 42. What remedies are available against arbitral award? Remedies against an arbitral award. While the principle of finality of arbitral awards is generally upheld, there are limited circumstances under which a party can seek recourse against an award. Primary remedy, setting aside the award. The most common remedy is to seek to have the award set aside by a court. The Arbitration and Conciliation Act, 1996, outlines specific grounds for setting aside an award, including corruption or undue influence, lack of proper notice, composition of the arbitral tribunal or arbitral procedure, beyond the scope of submission, public policy, other potential remedies, correction or interpretation. Parties can request the arbitral tribunal to correct clerical errors or interpret ambiguities in the award. Additional award. In limited circumstances, the tribunal can be asked to make an additional award on matters omitted from the original award. Enforcement. The prevailing party can enforce the award through court proceedings. It's important to note that the scope for challenging an arbitral award is limited, and the burden of proof lies with the party seeking to set aside the award. Question 43. Define mediation. Mediation. Mediation is a structured, interactive process where an impartial third party, the mediator, assists disputing parties in resolving conflict through the use of specialized communication and negotiation techniques. Key characteristics of mediation. Voluntary, parties must agree to participate in mediation. Neutral mediator, the mediator does not impose a solution but helps parties reach a mutually agreeable outcome. Confidentiality, mediation proceedings are typically confidential. Flexible, parties retain control over the process and outcome. The goal of mediation is to facilitate communication, identify common ground, and explore potential solutions to the dispute. Question 44. Foreign award. Foreign award. A foreign award is an arbitral award made in a country other than the country where it is sought to be enforced. In simpler terms, it is an arbitration decision rendered outside the jurisdiction where the award is being recognized or enforced. Key characteristics. Cross-border, involves parties from different countries. Foreign law, governed by the laws of the country where the arbitration took place. Enforcement, requires specific procedures for enforcement in a different country. Importance of the New York Convention. The New York Convention is the primary international treaty governing the recognition and enforcement of foreign arbitral awards. It facilitates the cross-border enforcement of awards by establishing a uniform framework. Question 45. Define conciliation officer. Conciliation officer. A conciliation officer is a neutral third party appointed by the government to mediate and facilitate the settlement of industrial disputes. They play a crucial role in preventing industrial unrest by promoting amicable resolutions between employers and employees. Key functions of a conciliation officer. Investigation, investigate the industrial dispute to understand its root causes. Mediation, facilitate discussions between the parties involved to reach a mutually agreeable settlement. Proposal of solutions, suggest possible solutions or compromises to bridge the gap between the parties. Report submission, prepare a report on the conciliation proceedings, including the outcome, to the appropriate government authority. Powers of a conciliation officer. Summoning parties, can summon parties involved in the dispute. Examining witnesses, can examine witnesses related to the dispute. Inspecting documents, can inspect relevant documents. It's important to note that a conciliation officer does not have the power to impose a binding decision. Their role is to create a conducive environment for the parties to reach a voluntary settlement. Question 46. What do you know about Lok Adalat? Lok Adalat, People's Court. Lok Adalat is a legal system in India that provides a platform for amicable settlement of disputes outside the formal court system. It is a part of the Alternative Dispute Resolution (ADR) mechanism. Key features of Lok Adalat. People's Court, Lok Adalats are often referred to as people's courts as they involve the active participation of common people in the dispute resolution process. Statutory backing, it has been given statutory status under the Legal Services Authorities Act, 1987. Amicable settlement, the primary goal of a Lok Adalat is to facilitate a compromise or settlement between the parties involved in a dispute. Final and binding, the decision or award made by a Lok Adalat is deemed to be a decree of a civil court and is final and binding on all parties. No appeal, there is no provision for an appeal against the award of a Lok Adalat. Free of cost, the services provided by Lok Adalats are free of charge. Types of Lok Adalats. Regular Lok Adalats, held periodically by legal services authorities. National Lok Adalats, held on a specific date across the country. Permanent Lok Adalats, established in certain high courts and district courts for continuous dispute resolution. Lok Adalats have been instrumental in reducing the pendency of cases in regular courts and providing speedy justice to litigants. Would you like to know more about the process involved in a Lok Adalat or the types of cases that can be resolved through it? Question 47. Discuss the law relating to appointment of conciliators. Appointment of conciliators. The appointment of conciliators can occur in various ways, depending on the specific context and applicable laws. General principles. Party autonomy. Generally, parties have the freedom to choose their conciliator. Impartiality. The conciliator should be impartial and independent. Expertise. In some cases, expertise in the subject matter of the dispute is desirable. Methods of appointment. Agreement of parties. The most common method is for the parties to mutually agree on the conciliator. Appointment by an institution. If the parties cannot agree, they may designate an institution or person to appoint the conciliator. Government appointment. In certain cases, government agencies may appoint conciliators, particularly in labor disputes. Court appointment. While less common, courts may appoint conciliators in specific circumstances. Legal framework. The specific provisions for the appointment of conciliators vary depending on the jurisdiction and the nature of the dispute. For instance, in India, the Arbitration and Conciliation Act, 1996, provides for the appointment of conciliators in commercial disputes. It's important to note that the method of appointment should be clearly specified in the conciliation agreement or the relevant legal framework. Question 48. Beginning of conciliation proceedings. Beginning of conciliation proceedings. Conciliation proceedings typically commence with a written invitation from one party to another to engage in conciliation. Key steps. Initiation. One party sends a written invitation to the other party proposing to resolve the dispute through conciliation. The invitation should briefly outline the subject matter of the dispute. Acceptance. The other party must accept the invitation in writing to initiate the conciliation process. Appointment of conciliator. Once the parties agree to conciliate, they may mutually appoint a conciliator or seek the assistance of an institution to appoint one. Important considerations. Voluntariness. Both parties must voluntarily agree to participate in conciliation. Confidentiality. The conciliation process is generally confidential. Flexibility. The parties have considerable flexibility in determining the procedures and timelines for conciliation. Once the conciliation proceedings have commenced, the conciliator will typically schedule meetings with the parties to facilitate communication and negotiation. Question 49. Role of conciliators. Role of conciliators. A conciliator is an impartial third party who assists disputing parties in reaching a mutually agreeable settlement. Their role is crucial in facilitating communication and negotiation between the parties. Key roles and responsibilities of a conciliator. Impartiality, maintaining neutrality throughout the process, avoiding taking sides. Active listening, carefully listening to both parties to understand their perspectives and concerns. Communication facilitation, creating a conducive environment for open and honest communication. Problem solving, helping parties identify the core issues and explore potential solutions. Generating options, suggesting possible solutions or compromises. Building trust, fostering trust and cooperation between the parties. Confidentiality, maintaining confidentiality of all information shared during the process. Structuring the process, guiding the parties through the conciliation process, including setting agendas and timelines. Essentially, a conciliator acts as a facilitator, helping parties to find common ground and reach a mutually satisfactory resolution. Question 50. Number of conciliators. Under the Arbitration and Conciliation Act, 1996, the default number of conciliators is 1. However, the Act provides flexibility for the parties to agree on a different number. Specific provisions. Section 63 of the Act states that there shall be 1 conciliator unless the parties agree otherwise. 2 or 3 conciliators. If the parties agree, they can appoint 2 or 3 conciliators. Joint action. In case of multiple conciliators, they are generally expected to act jointly. In conclusion, the number of conciliators is determined by the agreement of the parties. The default position is a single conciliator, but the parties have the autonomy to choose a different arrangement if they believe it would be beneficial to the conciliation process. Question 51. Role of conciliator in other modes of settlement of dispute. Role of conciliator in other modes of dispute resolution. While conciliation is a distinct form of alternative dispute resolution, ADR, the role of a conciliator-like figure can be observed in other ADR processes as well. Mediation. Similar role. The mediator's role is very similar to that of a conciliator in facilitating communication and negotiation between parties. Key difference: mediators typically have a more passive role, allowing parties to take the lead in generating solutions. Negotiation. Arbitration. Limited role. Arbitrators have a decision-making role, but they may use conciliatory techniques during the hearing to encourage settlement before rendering an award. Court-annexed mediation or conciliation. Hybrid role. In some jurisdictions, courts may appoint conciliators or mediators to assist in resolving disputes before or during litigation. These individuals have a role similar to conciliators in independent settings. In summary, while the formal title of conciliator may not be used in all ADR processes, the skills and techniques associated with conciliation are often employed by neutral third parties to help parties reach amicable settlements. Question 53. What are the appealable orders? Appealable orders. An appealable order is a court decision that can be challenged in a higher court. Not all orders are appealable. There are specific criteria and limitations. General categories of appealable orders. Final orders. These orders conclude a specific legal issue or case. They are typically appealable. Examples: judgment, decree, order dismissing a suit. Interlocutory orders. These orders are made during the course of a case but do not finally dispose of it. Generally, not appealable unless they substantially affect the rights of the parties or cause irreparable injury. Examples: orders granting or refusing injunctions, appointing receivers, or granting custody. Orders affecting substantial rights, even if not final, orders that significantly impact the rights of a party can often be appealed. Examples: orders rejecting a plaint, dismissing a suit, or striking out pleadings. Factors affecting appealability. Statutory provisions. The specific laws of a jurisdiction determine which orders are appealable. Discretionary appeals. Some jurisdictions allow appeals for certain types of orders at the discretion of the appellate court. Time limits. There are strict time limits for filing an appeal. Importance of appealable orders. Understanding which orders are appealable is crucial for parties involved in litigation. It helps them determine the appropriate course of action after an unfavorable order. Note: the specific rules governing appealable orders vary significantly between jurisdictions. It's essential to consult with an attorney to determine the appealability of an order in a particular case. Question 53. Difference between arbitration and valuation. Arbitration versus valuation. While both arbitration and valuation involve a third-party determination, they serve distinct purposes. Arbitration. Dispute resolution. Arbitration is a formal process to resolve disagreements between parties. Binding decision. The arbitrator's decision is final and enforceable. Comprehensive. Covers a wide range of disputes, including contractual, commercial, and personal disputes. Legal framework. Governed by specific arbitration laws and procedures. Valuation. Asset assessment. Valuation is the process of determining the monetary value of an asset or property. Expert opinion. A valuer provides an expert opinion on the value, not a legally binding decision. Limited scope. primarily focused on determining value, not resolving disputes. Contractual basis often arises from contractual obligations or legal requirements. In summary, arbitration is a dispute resolution mechanism, while valuation is a specialized process to determine value. While there can be overlap, particularly in cases involving valuation disputes, they are fundamentally different processes. Question 54. What are the powers of the central government to make rules? Powers of the central government to make rules. The central government in India derives its power to make rules primarily from the Constitution, specific statutes, and delegated legislation. Constitutional basis. Article 73. This article grants the central government the power to make rules for the efficient conduct of its affairs. Article 246. This article outlines the legislative powers of the centre and states, including the power to make laws on matters of national importance. Statutory basis. Delegated legislation. Most statutes confer rulemaking power on the central government to implement the provisions of the Act effectively. For instance, the Companies Act, Income Tax Act, and Consumer Protection Act empower the central government to make rules. Specific provisions. Certain acts explicitly outline the subjects on which the central government can make rules. Nature of rules. Subordinate legislation. Rules are subordinate to the parent act and cannot contradict its provisions. Detailed implementation. They provide the detailed mechanism for implementing the law. Flexibility. Rules allow for adaptability to changing circumstances. Subject to judicial review. Rules made by the central government are subject to judicial review to ensure they are within the scope of the parent act. Important considerations. Rulemaking procedure. The central government follows a prescribed procedure for making rules, including publication in the official gazette and laying before the parliament. Consultation. Often, the government consults with stakeholders before making rules. Judicial scrutiny. Courts have the power to review the validity of rules. In essence, the central government's power to make rules is a crucial aspect of governance, enabling it to adapt to evolving circumstances and effectively implement laws. Question 55. Whether the communication between conciliator and parties are confidential in nature? Confidentiality in conciliation proceedings. Yes, communication between the conciliator and the parties is generally confidential. This principle is essential to fostering open and honest dialogue between the parties. Key points. Protection of information. Information shared by the parties with the conciliator is typically protected from disclosure. Yes, communication between the conciliator and the parties is generally confidential. This principle is essential to fostering open and honest dialogue. Encouraging openness. Confidentiality encourages parties to be candid, which is crucial for successful conciliation. Legal provisions. Many jurisdictions have specific laws protecting the confidentiality of conciliation proceedings. Exceptions. There might be limited exceptions to confidentiality, such as when required by law or with the consent of the parties. By ensuring confidentiality, conciliation creates a safe space for parties to explore potential solutions without fear of their statements being used against them in future legal proceedings. Would you like to know more about the exceptions to confidentiality in conciliation or the importance of confidentiality in promoting successful settlements? Question 56. Whether conciliator is bound to observe the provisions of C.P.C. or Evidence Act. Conciliator and the C.P.C. or Evidence Act. No, a conciliator is not bound by the provisions of the Code of Civil Procedure, C.P.C., or the Indian Evidence Act. The rationale behind this is to provide flexibility and informality to the conciliation process. The primary goal of conciliation is to facilitate a settlement, and rigid procedural rules might hinder this objective. Key points. Section 66 of the Arbitration and Conciliation Act, 1996 explicitly states that a conciliator is not bound by the C.P.C. or the Evidence Act. Flexibility. This exemption allows for a more informal and flexible approach to dispute resolution. Focus on settlement. The emphasis is on reaching a mutually agreeable solution rather than adhering to strict procedural formalities. Principles of natural justice. While not bound by the C.P.C. or Evidence Act, a conciliator is expected to adhere to the principles of natural justice, such as fairness and impartiality. By freeing conciliators from the constraints of procedural laws, the legislature intends to promote efficiency and effectiveness in dispute resolution. Question 57. Whether the statement has to be submitted to conciliator? Submission of statements to conciliator. Yes, the submission of statements to the conciliator is generally required. Section 65 of the Arbitration and Conciliation Act, 1996 empowers the conciliator to request each party to submit a brief written statement describing the general nature of the dispute and the points at issue. Key points. Conciliator's discretion. The conciliator may request further written statements with supporting documents at any stage of the conciliation proceedings. Purpose. These statements help the conciliator understand the dispute and facilitate the conciliation process. Exchange of statements. Parties are required to share copies of their statements with each other. While the submission of statements is not mandatory in all cases, it is generally considered good practice as it helps to clarify the issues in dispute and promotes efficient conciliation. Question 58. Give the rules regarding the costs in conciliation proceedings. Rules regarding costs in conciliation proceedings. The Arbitration and Conciliation Act, 1996, provides for the allocation of costs in conciliation proceedings. Section 78 of the Act outlines the following. Costs to be fixed by conciliator. Upon termination of the conciliation proceedings, the conciliator shall fix the costs and give written notice to the parties. Components of costs. The costs include the fee and expenses of the conciliator, witnesses, expert advice, and other expenses related to the conciliation proceedings. Equal sharing of costs. Unless otherwise agreed upon by the parties, the costs are borne equally by them. Additional points. Settlement agreements. If the parties reach a settlement, they can agree on how the costs will be divided. Discretion of conciliator. The conciliator has discretion to apportion costs differently based on the circumstances of the case. In essence, the general rule is that the costs of conciliation are shared equally by the parties unless otherwise agreed upon. However, the conciliator has the authority to make adjustments based on the specific facts of the case. Question 59. Cooperation of parties with conciliator. Differently based on the circumstances of the case. Cooperation of parties with conciliator. Cooperation of the parties is essential for the success of a conciliation process. The conciliator's role is to facilitate a settlement, but the ultimate decision to settle rests with the parties. Obligations of parties. Good faith. Parties are expected to participate in the conciliation process in good faith. Compliance with requests. Parties should comply with the conciliator's requests for information, documents, and attendance at meetings. Open communication. Parties should be open and honest in their discussions with the conciliator. Consideration of proposals. Parties should carefully consider the proposals and suggestions made by the conciliator. Consequences of non-cooperation. Impeding the process. Non-cooperation can hinder the conciliator's ability to facilitate a settlement. Negative impact on relationship. It can damage the relationship between the parties. Potential for increased costs. Prolonged disputes can lead to higher legal and other costs. In essence, the success of conciliation largely depends on the willingness of the parties to cooperate with each other and with the conciliator. Question 60. Final award. Final award. A final award is the final decision of an arbitral tribunal in a dispute. It is the culmination of the arbitration process and represents the tribunal's resolution of the matters submitted to it. Key characteristics of a final award. Binding and enforceable. A final award is generally considered final and binding on the parties involved. Termination of proceedings. The issuance of a final award brings the arbitration proceedings to a close. Comprehensive decision. It addresses all issues and claims raised by the parties. Clarity and specificity. A well-drafted final award clearly states the findings of fact, conclusions of law, and the relief granted to each party. Importance of a final award. Dispute resolution. It provides a definitive resolution to the dispute. Certainty. Offers certainty to the parties regarding their rights and obligations. Enforceability. The finality of the award is crucial for its enforcement. In essence, a final award is the culmination of the arbitration process and serves as the foundation for enforcing the rights and obligations determined by the arbitral tribunal. Question 61. Termination of conciliation proceedings. Termination of conciliation proceedings. Conciliation proceedings can terminate under the following circumstances. 1. Successful settlement. Agreement. Parties reach a mutually agreeable settlement. Settlement agreement. A formal agreement is drawn up outlining the terms of the settlement. Termination of proceedings. Once the settlement agreement is signed, the conciliation proceedings are terminated. 2. Failure to reach a settlement. No agreement despite the conciliator's efforts. The parties are unable to reach a settlement. Declaration of failure. The conciliator issues a declaration stating that the conciliation has failed. Termination. The conciliation proceedings are terminated upon issuance of the declaration. 3. Withdrawal by a party. Unilateral termination. A party can unilaterally withdraw from the conciliation process. Notification. The withdrawing party must notify the other party and the conciliator in writing. Termination. Upon receipt of the withdrawal notice, the conciliation proceedings terminate. 4. Other grounds. Impossibility of conciliation. If the conciliator determines that there is no possibility of reaching a settlement, the proceedings may be terminated. Death or incapacity of a party. The death or incapacity of a party may lead to the termination of the conciliation process. It's important to note that while the conciliation process can be terminated, the underlying dispute still exists and may require alternative dispute resolution or litigation. Question 62. What do you understand by mini-trials? Mini-trials. A mini-trial is a form of alternative dispute resolution, ADR, that combines elements of negotiation, mediation, and trial. It is a structured process designed to encourage settlement of a dispute without resorting to full-blown litigation. Key features of a mini-trial. Abbreviated presentations. Each party presents a condensed version of their case to a neutral advisor and representatives from both sides. Neutral advisor. A neutral third party, often a retired judge or experienced attorney, observes the presentations and may provide an advisory opinion. Settlement negotiations. Following the presentations, the representatives from each side attempt to negotiate a settlement. Non-binding. The neutral advisor's opinion is non-binding, but it can provide valuable insights into the strengths and weaknesses of each party's case. Advantages of mini-trials. Cost-effective, less expensive than full-scale litigation. Time-efficient, faster resolution of disputes. Preserves relationships, can help maintain business relationships. Improved understanding, provides parties with a clearer understanding of the case. In essence, a mini-trial offers a structured and efficient way to resolve disputes while preserving the opportunity for settlement. Question 63. What is professional assistance? Professional assistance. Professional assistance refers to the support or guidance provided by a skilled individual or organization in a specific area of expertise. It involves seeking help from professionals to address a particular challenge, problem, or goal. Examples of professional assistance. Legal advice from an attorney. Financial guidance from a financial advisor. Medical care from a doctor or nurse. Mental health support from a therapist. Technical support from IT professionals. Business consulting from a management consultant. Key characteristics of professional assistance. Expertise. Professionals possess specialized knowledge and skills. Objectivity. They provide unbiased advice and solutions. Efficiency. Professionals can often solve problems more quickly and effectively. Cost-effective. In many cases, professional assistance can save time and money. In essence, professional assistance is about leveraging the expertise of others to achieve desired outcomes. Question 64. What do you understand by legal representative? Legal representative. A legal representative is a person who acts on behalf of another individual or entity in legal matters. They have the authority to represent the interests of the person or entity they represent. Examples of legal representatives. Executor or administrator of an estate represents the deceased person's estate. Guardian or parent represents a minor child. Power of attorney, a person granted authority to act on behalf of another. Corporate officer represents a corporation. Attorney represents a client in legal proceedings. Key roles and responsibilities. Making decisions, acting on behalf of the represented party in legal matters. Signing documents, signing legal documents on behalf of the represented party. Representing in court, appearing in court to represent the interests of the represented party. Managing legal affairs, handling legal matters, such as correspondence, negotiations, and litigation. It's important to note that the specific powers and responsibilities of a legal representative vary depending on the legal relationship between the representative and the represented party. Question 65. Problems. Problems, a challenge to overcome. A problem is a situation or circumstance that presents difficulty or requires a solution. It's an obstacle that stands in the way of achieving a desired outcome. Problems can range from simple inconveniences to complex issues with far-reaching consequences. Types of problems. Problems can be categorized in various ways. Personal problems, challenges faced by individuals, such as financial difficulties, relationship issues, or health concerns. Social problems, issues affecting communities or societies, like poverty, inequality, or crime. Global problems, challenges that impact the entire world, such as climate change, pollution, or terrorism. Technical problems, issues related to technology or systems, such as software glitches or hardware failures. Problem-solving process. Addressing problems often involves a systematic approach. Identify the problem, clearly define the issue. Analyze the problem, understand the causes and effects of the problem. Develop solutions, brainstorm potential solutions. Evaluate options, weigh the pros and cons of each solution. Choose affecting communities or societies, like poverty, implement the solution, choose the best solution and put it into action. Evaluate the outcome, assess the effectiveness of the solution. Would you like to discuss a specific problem or problem-solving technique?